Welcome back. Governor Cooper is throwing his 2 cents into a Supreme Court lawsuit involving UNC Chapel Hill.
Yeah, he's supporting his alma mater by arguing that using race should be used as a factor in college admissions. Our chief political correspondent, Emma Withrow, joins us now to explain both sides of this complicated case. Emma?
That's right, guys. So UNC Chapel Hill is the defendant in a case filed by a group called Students for Fair Admissions, who argue race should not be a factor for consideration when applying for college. UNC argues it should be, and Cooper also agrees. So he filed this amicus brief to put his argument into writing. He filed that yesterday. Now, an amicus brief is a document from an individual or group who's not a party in the lawsuit, but is able to help the court by providing some sort of expertise or insight that might impact the case. So the people who file an amicus brief are called amici. You're going to want to hear that later. But the UNC is not the only college that's going to be under the microscope in the Supreme Court. So UNC as well as Harvard are both being challenged by the same group, that group Students for Fair Admissions. So if the high court rules in that group's favor, it could overturn the legality of affirmative action. The Supreme Court decided to take up these cases back in January, which has led to tons of scholars, companies, and politicians and more to write these amicus briefs. So Cooper's amicus brief argues diversity in education fosters diversity in government and supports race being used as a consideration in college admissions. It says democracy, quote, demands leaders who reflect the diversity of people they govern. But for much of our nation's history, the path to leadership for racial minorities has been strewn with obstacles. As leaders of southern states, amici know all too well the detrimental effects those obstacles can have not only on individual residents, but on the enterprise of government itself. But I spoke with some other groups who support the petitioner, that group Students for Fair Admissions, and Wen Fa, a senior attorney at Pacific Legal Foundation, and then Ken Marcus, the chairman of the Brandeis Center for Human Rights Under Law. Both wrote amicus briefs and agree that race should not be a factor in admission. Take a listen to what these other amici on the opposite side of the argument had to say today.
Universities first adopted the diversity framework, not because they wanted to have more Black or Hispanic students, but because they wanted to have fewer Jewish students. Much of the way that universities continue to look at diversity is based on some of these building blocks that are actually very dubious in their historical background, even if the current admissions officers have different ideas in mind.
There was a 2003 decision at the University of Michigan Law School, which allowed the use of racial preferences in higher education. And we believe that decision was wrong. And not only was it wrong, but it continues to have a profound effect on students applying to universities across the country. You have guides like the Princeton Review stereotyping Asian applicants to these universities, saying that they shouldn't say that they want to, play the piano or major in math or sciences or become a doctor, because doing so would decrease their chances of getting admitted.
So Wen, who you just heard there, said he expects arguments to be heard later this year, potentially in November, and then he says a Supreme Court decision could be made sometime in the summer of 2023. So that's where we're at with that.
And we know the Supreme Court, just in the last couple of months, have made huge decisions, huge controversial decisions. What do you think in terms of the Supreme Court regarding affirmative action and using race as a factor for these schools?
So a lot of people have been speculating that by just having the Supreme Court take on these two cases with UNC and Harvard, shows that there could be some sort of reform when it comes to the legality of affirmative action and how it plays out in our college admissions process. We have a lot of people looking at this and revisiting it, just like they have with the abortion cases. And so when you're looking at how this is going to play out, it's all going to depend on that conservative majority in the Supreme Court, whether or not they're going to dig their heels in. And it's all up for speculation at this point. Big companies like GE and Apple have actually written amicus briefs in support of UNC and Harvard, because a lot of their workforce comes from those types of schools. So there's a lot of players and a lot of different things happening here. And so we're just going to have to watch how it plays out in the coming months.